All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. We're here today in the matter of Northern Arizona Healthcare Corporation et al. V. City of Flagstaff and Flagstaff Community First Real Party and Interest. Our case number 1 CA-CV23-0488, an election matter. We have counsel for plaintiff and appellants and counsel for Real Party and Interest. Is counsel for the city here as well? No. Okay. I wouldn't necessarily expect them, but if they were here, I was going to acknowledge them. We're here today for oral argument in this expedited election matter. As you probably know, this is being, I think, live streamed probably on YouTube, so all 3 people in the world that will be watching this can track along. And it'll also be posted later to YouTube as a recording. So please, when you get up and announce yourself, please announce yourself and say who you represent so people watching can figure it out. We have conferenced this matter. We've reviewed the briefing and the appendix that you provided and that the parties provided. So we are relatively familiar with the facts, but feel free to tell us about what you think we need to know. I think we've covered it all. Each side gets 20 minutes. It'll be up to you to keep track of your time. If you want to reserve any time, appellant, for rebuttal, it's up to you to do so. And with that, we can proceed.
Thank you, Your Honors. Good morning. May it please the Court, Daniel Ariano for Northern Arizona Healthcare Corporation and Douglas Loudon, who's here with us in the courtroom this morning. With the Court's permission, I'd like to reserve about 5 minutes for rebuttal, if I may. The ordinance in this case rezones property for a new regional hospital. And what we're dealing with is a referendum description that hides that fact. It obscures the point both by omitting it and by making it seem as if things like the fact that there's an effective date or severability were somehow the more important parts that voters really needed to know about. And then it makes matters worse by suggesting that what's actually going to go on this property are things like a strip mall. That was false. The law requires referendum proponents to provide signers with a summary that accurately describes the principal provisions of the measure being referred. The point is to give signers the essential, truthful information they need to decide in short order whether to sign the petition or not. The requirement is that the petition describe all of the principal provisions of the measure and that it do so accurately. And the description here failed on both. It failed first to describe all principal provisions of the zoning ordinance because it failed to note that the hospital was the purpose for which the land was being rezoned. And the ordinance rezones lands...
Don't the cases tell us that the purpose is not necessarily an essential element?
So I think, Your Honor...
Or the intent, if that's a different word.
Sure, Your Honor. I think the cases, as we read them, generally stand for the proposition that anticipated effects of legislation, I think, generally are not the types of things that you need to include in a description. But when the purpose, I think, or the ends of the legislation are expressly baked into the legislation itself, then I think it can be a principal provision, and that's what we think it is here. And I think a couple of the initiative cases are instructive in this regard. So if you look at Malera 2, that was a measure that involved both raising taxes and dedicating the resulting funds for education, and the Supreme Court said that that measure complied, the description complied, because it mentioned both of those as principal provisions. I think the contractor's case does the same thing. It says that it will end certain light rail extensions and it will dedicate the resulting funds for this other thing. So,
am I correct that this is the ordinance being referred is 23-11?
That's correct, Your Honor. Yes.
Does 23-11 say hospital in it?
It does, Your Honor. So it says it in the very first recital. So I think I think the ordinance here specifies that this land is being rezoned for a hospital in 3 different ways. The first, I think, which is the most clear, is that that very first recital, which, by the way, is incorporated into the first section of the operative text and the next page, but the first recital says that the ordinance is acting in response to an application to rezone property, quote, for the purpose of being developed with a regional hospital, ambulatory care center, and associated open space and civic space. So we have that expressly in the terms of the ordinance, even if we're looking only at the, the legislative text of these first 3 pages or so. Second, it says expressly on the next page that the zoning amendment is contingent on the developer here, Northern Arizona Healthcare, satisfying a set of conditions, 2 of which are compliance with the specific plan and the development agreement, the centerpiece of both of which is the development of this hospital. I think together they reference the hospital over 100 times. And finally, the last condition on that second page says that the zoning will revert if final approval is not obtained within 2 years. And I think that's a very important point because by law, a city can hold...
Wait a second.
Sure.
Does it say it will revert?
Well, it says it can revert. It says if final approval is not obtained within 2 years.
That's a very big difference in my mind. So I think you want to speak very precisely.
Sure, of course, Your Honor. So I think the point is that the city has the power to revert the zoning classifications to their prior classifications.
Does it say the city will?
It doesn't say the city will. It doesn't say the city will, but the city can. And legally, Your Honor...
Can't the city do that anytime, like change zoning classifications?
Can
they do that here? I mean, how is that, how saying that we may take a future ordinance and pass a future ordinance changing the zoning classification different than what they did here?
So I think the point matters, Your Honor, because by law, the city can hold a developer to the use for which it has requested the rezoning, and it can do so on penalty of reversion. I'll grant you true. Whether it actually will do that or not, we of course don't know, but it certainly...
And let's say the hospital walks away from this deal a year later, so financially just can't do it, can't come up with the funding, whatever.
Then I think that is a circumstance that is precisely contemplated in that last condition, which is that the city...
Couldn't the city then decide, we're just going to leave it now commercial residential and find a new developer to do something else with it?
Sure, they could do a number of things.
But at that point, then the voters couldn't go back and challenge the referendum. It would be past the time to submit this for referendum.
Sure, Your Honor, but I think the point is that the referendum had to describe what this ordinance does.
I was very happy in your reply. You very carefully said may,
Sure.
4 times, but here in argument, you just said will. So I'm just going to, again, emphasize, that is a very important point to me. I don't speak for the entire panel. And don't change your argument.
Of course, Your Honor, I apologize for not being more precise. My point is, and I think the point remains, that the city has the power to revert the zoning ordinance, or the zoning classifications to their
just like they did here in 2311.
Sure, I don't think that was quite a reversion, but it was a zoning change, right? The city has the power to zone property. But I think it tells, I think, both Northern Arizona Healthcare and the public that if this thing doesn't do what it says it's going to do, then we have the power to then call a city council meeting, and then one of the things they can consider is reversion. And the reason why we think that point matters legally is because by statute, the cities have the power to hold a developer to the requested use. And so I think the broader point I'm trying to make here is that by Northern Arizona Healthcare requesting that this property be rezoned specifically for a hospital, the nature of that request carries enormous legal significance. And we of course don't know this for certain, but I think it's fair to say that it's pretty unlikely that they would get final approval if they do not build the very thing that they have promised.
Let's walk through that thing that we were just talking about. Again, let's say something happens and it doesn't happen. The hospital doesn't happen.
Sure.
So city council says, you're out, NAH, it's no longer your property to develop. What happens then?
Well, NAH still owns the property, but I think then it would face...
So NAH sells it to someone else.
That's right, Your Honor. And then if NAH were to sell it, then the city council would then have the option, I think, to then bring in someone new to then develop the property. I mean, this case, I think, that circumstance would be contemplated.
I want to focus in on the point of the voters may be just completely without remedy at that point.
I don't think that's quite correct, Your Honor.
Well, it's been rezoned commercial, subject to this plan, with the city reserving the right to change it if the plan doesn't go through. But there's no more, it's now zoned commercial.
Sure, Your Honor, but the remedy of the voters is the referendum power, and we don't dispute that this is a referable act that had all the requirements been complied with, what could have been referred.
Would it be a
to the ballot.
referable act if the city doesn't act in the future to revert it?
I suppose it would depend on what action the city council took in response to that. I mean,
Because
because
if the city just takes no action, leaves it commercial resident, or commercial, highway commercial, there's no action to refer.
I think at that point, probably not, Your Honor, but the point is that,
And your client would be selling that property, if the hospital didn't go through, as zoned commercial. I mean, it would be legally available to them to say, we're selling this property, and oh, by the way, it's zoned commercial.
so and to be clear, I don't know whether Northern Arizona Healthcare would sell the property, but I think if they were to, that zoning classification would probably stick. And I think those circumstances would be complicated pretty substantially by the fact that we also have a development agreement between NAH and the city, so you'd have to, I think, look at the remedies under that. You have the specific plan.
But I think we're trying to circle back to the fact that the ordinance itself that they referred is about the change in classification of the zoning.
Correct.
And that they mention the healthcare corporation, they mention in it the specific plan, but at bottom, what they referred was not the specific plan, it was the zoning change. And you're saying that if the specific plan isn't followed through with, that your client, I understand it's a lot of
Sure.
hypotheticals, but your client would then own commercially zoned land that if this didn't go through, they could sell as commercially zoned land, and then who knows what happens. And the citizens are saying in this, we're agreeing that this is zoned residential, or zoned commercial.
Right. So, Your Honor, I think these are all circumstances that I think would get to, like, what are the effects of the legislation? What are the effects if things do or don't happen? And what we're dealing with at the end of the day is a requirement that this petition describe what this ordinance does. I suppose, these circumstances of what happens if NAH doesn't follow through, it wouldn't be unlike, for example, the Invest in Ed case initiative in Malera 2, which is, it could happen that it doesn't raise enough tax revenues to actually fund education. It could happen that the initiative fails ultimately for some other reason, which is actually what happened. It never actually went into effect. But at the end of the day, regardless of what all those possible after-the-fact contingencies are, what we're dealing with is the referral of this ordinance, and we have to look at this ordinance and what this ordinance does by its terms in determining whether this petition accurately described all principal provisions of the ordinance. So, I think I've listed the ways in which this ordinance, I think...
If their description had just said, for purposes of a hospital, those 3 words.
I think that would have been sufficient, Your Honor. If it didn't also make the retail point, which I'll address next, but I think if it didn't address that retail point and just said for a hospital, I do think that would have been sufficient. I think that would have accurately described all principal provisions.
And it's not sufficient that it says, as requested by Northern Arizona Healthcare Corporation and as amended within the NAH Village Phase 1 specific plan. It seems like, boy, that's an awfully fine hair for us to split. That's not the right word. Splitting hairs, yeah. Awfully fine hair for us to split to say, for a hospital be enough, but NAH healthcare and pursuant to the plan is not.
Sure. So I don't think the name of the applicant itself puts people on notice that this is for...
Really?
There are a number, I think, of healthcare entities that run things other than hospitals. There could be nursing homes. There could be rehab facilities. There could be, I don't know...
Well, those would be allowed under the thing. Rehab facilities would.
I don't, if it were perhaps part of the hospital, I think.
I just, believe me, there's a lot we've tried to digest in the last
I understand, Your Honor.
time, but I remember when reading the plan, there was a description of secondary facilities for rehab or something along those lines.
Sure, and this development overall does do a number of things, right? And I think what's important to keep in mind here is that we're talking specifically about the 63.2 acres that are zoned specifically for the hospital. And I think that matters because when we're talking about, for example, the descriptions reference to what I'll refer to as retail goods stores for short, this notion of retail trade businesses or establishments engaged primarily in selling or offering for sale personal property to the public. That's, to use their terms, it's a mouthful. But we're talking about that part of the description. We're not talking about what's going to happen overall in the development, what might happen eventually in subsequent phases. We're talking specifically about what will happen and what will be allowed on these 63.2 acres rezoned to highway commercial.
And you acknowledge that there would be some retail good sales allowed.
There would be
the plan.
That's right, Your Honor. And again, talking specifically about so in subsequent phases of the development, there will be more broad, kind of your traditional types of retail. Yes, we've acknowledged that point. And specifically on this parcel, this 63.2 acres, there are some forms of retail that are allowed, very narrow forms, and they must be ancillary or accessory to the primary use of the land as a hospital.
So how is it deceptive to say that there would be establishments engaged primarily or selling or offering for sale personal property to the public?
So I think it's deceptive in a couple ways, Your Honor. The first,
I will agree with you. An average voter may read that and say, oh, they're putting in a Walmart. Okay. Yeah. But they could also say, well, this would allow a farmer's market or a donut shop or whatever else would be actually allowed. So how is this inherently so deceptive that we can't let the voters have their say on this?
So I think so it is deceptive, and I should note first, you have to read this how a reasonable person would. That is what the cases say. We don't apply kind of legalistic definitions to how it is read. We read it as a reasonable signer would. And I think when you read the term retail trade businesses or establishments engage themselves primarily in the sale of goods, that's a store. That's what this is describing, as a retail goods store. We're talking about a Walmart or a Best Buy or a strip mall. That is, I think distinctly what this evokes, and what it's meant to evoke is precisely that kind of impression that you're going to take this development of pristine land and put a strip mall there. And I'm happy to kind of go through the language too. I mean, I think the main argument in response to this, as we read it from the committee, is that, well, a flea market at least sells goods, so therefore that's an establishment that.
I'm just so curious. How is a farmer's market ancillary to the needs of the hospital, or a flea market?
So I think and this goes to the overall restriction, which is that it be ancillary accessory to the hospital, and so which means it must be in support of or customarily used with the hospital. And I think what the hospital was trying to get at here were health fairs, where food or goods might occasionally be sold. It's outdoors, it's Flagstaff, it's obviously really nice in the summer. This entire development collectively is meant as a kind of collective civic and open space, and so I think it's intended to promote healthy living within the community building generally, and so I think those are the types of activities, my understanding is, that would fall within that classification. Which I think also, by the way, hits on a broader point, which is that, this development has to work with the zoning classifications as they exist, right? And then it has to modify them to allow more precisely for the things they actually want to do.
But if I'm a mom and pop, soap maker, and I have an establishment, down the road, but I'm going to bring my soaps to the farmer's market, how am I not a retail trade business that's engaged primarily in selling my soap for, I understand what you're saying is that the first thing that pops into your mind is a Walmart.
Right.
But is this in error, which is what we have to look at? Is this misleading? Is it false? And under that scenario, how is this language false?
So I think, the part of the description that we take the most issue with is the second clause of it, right? So it talks about retail trade businesses, which, maybe arguably would encapsulate that, or establishments engaged primarily in the sale of goods. So I think the term establishment and engaged primarily are both key operative terms of that description. So I don't think that a temporary flea market, which again, by definition, flea markets are temporary, they're outdoors, they're in unenclosed spaces. I don't think a temporary flea market is an establishment in that sense. And I think the term establishment is meant to evoke specifically like a brick and mortar store.
Isn't this, and I understand the dispute that you guys are arguing about between, they'll say, we just took that from the code. That's what commercial allows, highway commercial allows. And you say, well, but here it's limited because of the plan and ordinance 2, et cetera. But I hear you acknowledging that if the deal doesn't go through, we're back to this, the overlays from ordinance 2 and the plan don't apply, and we're back to highway commercial. So isn't that at least partially accurate? Maybe it's somewhat incomplete, and there's certainly a lot more of detail that needs to be provided, or that will be provided during the election season, but isn't this accurate?
So I don't think so, Your Honor, because again, the zoning change is contingent on the terms of the specific plan and the development agreement. And those require that this property be developed in a very specific way. So I think without those things in effect, or without the property being developed in the way that those documents require, which again is for a hospital, I don't think the zoning
Is
change
the language that the amendment is conditioned upon the corporation satisfying several conditions not enough? Tell me why that's not enough.
I don't think it's enough, Your Honor, because the terms, the description itself, don't say what those conditions are. It's not enough to just say that there are conditions.
Well, are you saying they had to list all the conditions when they actually said within this that it is conditioned on an amendment within the Health Village Phase specific plan? And how much more would they need to say, in your view, to satisfy the point you're making now?
So it's, just to be clear, Honor, it's not our position that they had to go in and describe all the provisions of the incorporated documents. What they had to do was describe the principal provisions of the ordinance. And our point with respect to the specific plan, the development agreement, is this committee took it upon itself to go beyond the four corners of this zoning ordinance and take a stab at describing what this does. And they say they did so by merely quoting the Flagstaff City Code. It was actually the old repealed development code that they cited. But our point is, if you're going to go beyond just the four corners of like this specific document, you have to do so accurately. So then that puts at issue what the specific plan allows and doesn't allow. In other words, if this description is going to take it upon itself gratuitously to try to mention what it is allowed here, it has to do so accurately. And I think that question is informed squarely by the specific plan.
Your point is, if it doesn't say hospital, it can't pass muster, is that correct?
Yes, that is our first point, that it doesn't say hospital, and so it can't pass muster regardless of whether it's false or misleading, which is what Malera 2 says. And then secondarily and independently, it also fails because it conveys objectively false and misleading information.
And the only place we find hospital in the ordinance that you're challenging is in the first whereas, where it simply says the purpose is to establish a regional hospital. I think there's more to it. Ambulatory care center, and it's not even for the principal purpose, just for the purpose of being developed with a regional hospital, ambulatory care center. We haven't even talked about what that is. I'm not sure what that means, although I assume it has something to do with the trauma level, and associated open space and civic space. So all of this rides on one clause at the end of the first whereas statement.
So if we're looking only to, again, the first 3 pages or so of legislative text, I think that is the point where the hospital is mentioned explicitly. And I think, it's telling that the committee went on to describe other things, like the fact that there's an effective date, the fact that there's severability. I don't think it could honestly make the argument that it somehow missed the fact that the hospital was there, yet made it a point to emphasize all these other things. And I think...
Well, and I don't think it's, the case law doesn't say, if they omitted something, then, they can make a determination about what they include. It's only if they omitted something that makes it misleading.
Sure, if they omit a principal provision, Your Honor. And one point on this that I think is instructive from the cases in Malera 1, you can look to what the committee chose to emphasize to help inform what is a principal provision. And so here, we're not talking about some arcane buried point. The committee itself chose to emphasize what it thought this property would be used for.
Do we have any case out there because here we have 3 different moving parts. And you're taking 2 moving parts that are not on the ballot and are not part of this and arguing that because of 2 other moving parts, this one is wrong. Sort of along the lines of when the legislature sends an initiative to the ballot and they enact legislation that's contingent on it passing. Is it wrong to not include everything that may be key in that contingent legislation? Because I don't see a case out there that goes that far.
So I think generally there's no independent obligation to also include the provisions of incorporated documents. And I think our point is that those incorporated documents buttress the point that this is for a hospital, and the hospital, you can glean that point from the terms of the ordinance itself. To your question, Your Honor, there are cases suggesting, just for, in the interest of candor, there are cases that say, for example, the requirement that you attach the measure, that requirement doesn't extend to those incorporated provisions. It is enough to attach just what we refer to as the 4 corners of the ordinance, the actual legislative text, those 3 pages. So our point is not broadly that they had to go digging through hundreds of pages and kind of try to glean what was important and what wasn't. It was, 1, that they had to mention the hospital, which I think they had ample room to do, and 2, if they were going to take it upon themselves to then go beyond the four corners of the document, they needed to do so accurately, and they didn't, and they failed to do so here. And so for both of those independent reasons, Your Honor, we would maintain that this measure is invalid as a matter of law and would urge the reversal of the Superior Court.
Thank you very
Thank
much.
you, Your Honor.
I think we went about a minute over, so we'll add a minute to appellee's time, if you both agree.
Sorry, sure.
And that will be it.
Good morning, Your Honors. Jim Barton on behalf of Real Party and Interest, and may it please the Court. I think it might be helpful to talk about how we went about developing the 200-word description. And the place that we started, honestly, was the title of the measure. And so, you know, the City Council provides a title of the measure that's a narrative, and it identifies, for example, the zoning change and what they changed from and what they changed to. In that top thing there, they identify the address. And they put in the clauses that it's severability, that there's clerical corrections, and that it establishes an effective date. So I'm not sure why it's confusing that we included those in the description. The City Council agreed those were provisions.
You're sure why it's confusing. You know what their argument is.
Well, thank you, Your Honor. I'm sorry for my disingenuousness. But let's talk about the second half. So I think that including those things in the description was because they're included in the title, and evidently the City Council believes that they're principal provisions enough to put in the narrative title. So we included them in the description. Then the second half of the description, we do start out by saying the Northern Arizona Healthcare Corporation is the sponsor of this. We do talk about, good guy things that they're doing. For example, we identify it's been approved by the City Council. We talk about it being conditioned on things. And as you talked about with Mr. Ariano, we in fact talk about these requirements, including zoning codes, are going to be amended within the NAH Health Village Phase 1 specific plan. So I'll just submit that if we were trying to hide the fact that this was a hospital, we did a bad job of that, because we mentioned that there was a healthcare corporation, and then we identified that the specific plan was actually called a Health Village Phase 1 specific plan. No one was trying to hide anything. And in fact, we did not put in the purpose of the measure, the motivation of the measure, because those are not operative provisions of the measure. And I think that, the trial court, did in fact specifically say this, that we didn't have to include the word hospital, and quoted Malera 2, that what we need to do and what we did do is include the measure's key operative provisions. I do think SCLAR helps here. SCLAR, in that case, SCLAR v. Fountain Hills, they try to refer to measures, and they basically try to use the same description. And the court said you can't do that. Your description has to be of the measure that you're referring. You're referring to, that needs to have two different descriptions. And then frankly, in Malera 2, I found it very instructive when they were discussing the pass-through income. You raise taxes on, quote, rich people, right? And so the opponents are like, well, yeah, but there's also businesses, and this pass-through, it's going to fall to the tax too. But the Supreme Court said in Malera 2, yeah, but the fact that the pass-through income would be taxed, that's a character of the tax law. That's not a character of the Invest in Ed Act, the second Invest in Ed Act. And so I think that we're in a similar place here, just to start off when we think about the provisions of 2023-11 are to change the zoning, and that's it. And then do these other things like the effective date and like that. So, yes, I'm sorry.
There's a part of me that finds your argument very appealing, but then there's a second part of me that says, but this is phase 1 of a 3-part interrelated thing, and there's no dispute that if this leg is yanked out of the stool's tumbling over. You'd agree with that, right?
Yes, Your Honor.
Okay. And it, in fact, all 3 of them were kind of, I think the development agreement, the ordinance, and Ordinance 2 were all kind of passed at the same time.
Yes, Your Honor.
I didn't see language saying that necessarily they're contingent, but I think they are contingent in effect. So how are you able to not provide a more fulsome picture of what the overall deal is going to be when throwing out Ordinance 1 is going to throw out the entire thing?
Your Honor, we provided a very fulsome picture. We described what the ordinance would do by changing the zoning. We identified the fact that it's a healthcare corporation that wanted the zoning change, and then we identified that there's a specific plan that's going to create a health village or an AAH health village, whatever. I think we did a great job of describing everything that was happening. No, we didn't use the language for the purpose of a hospital and ambulatory care, et cetera, and so on. But again, the purpose of, the motivation behind the zoning change, that's not an operative provision that the citizens can approve or disapprove. That's a piece of background. I think we gave that background by the things that we've already talked about, but in any case, it's certainly not an operative provision. If you again,
I'll tip my hand a little bit.
Yeah.
I think that by saying NAH Healthcare or Northern Arizona Healthcare and referencing the village plan, you've given enough information there that the reasonable voter could look at this and say, well, there's something hospital-related going on here. Not to diminish your arguments about, well, there's other things, but it at least clues people in. This isn't Walmart seeking it. This is a healthcare corporation seeking it. But I am troubled by the references to the retail establishment, et cetera, that you put in your description. When it does, as I read, at least all three of these things combined together would put severe limits on those. Can you respond to that? Do you acknowledge that the combined plan would not allow a retail establishment?
No, Your Honor, I don't acknowledge that because the combined plan explicitly identifies a retail establishment, such as a restaurant or cafe, such as a farmer's market, such as a flea market. So, I mean, for a starting point for us...
Is a flea market an establishment?
I mean, yes, a flea market is I suppose it depends how transient it is. Certainly a restaurant is an establishment. Certainly a cafe is an establishment. If you look...
Would a swap meet count as a flea market? Like the one park and swap in Phoenix that I think was probably about the size of this property?
Your Honor, it seems like yes to me. I mean, that is an establishment. That's a place where you go to do retail exchanges. But I mean, I'm not sure if a permanence is necessary. I am sure that in the specific plan...
But it doesn't exclude a permanent one.
It does not exclude a permanent
In
one.
other words, it could be a permanent park and swap, like we have here in Phoenix.
Thank you, Your Honor.
sometimes.
Yes, exactly. It could be. In fact, it says, when it's describing, and this is the paragraph, section 1A of the specific plan, it says that in addition to bringing the facilities, it says together with a broad mix of commercial, retail, research, and housing opportunities. So our position was that we just wanted to tell people what highway commercial is.
That wasn't, I mean, I don't want to cut off your point, but that wasn't for the highway commercial part of the plan, right? I mean, that's a different phase. And so the troubling reference that I think Judge Morris was reading from is the dash after what's going to happen to the 63.18 acres. And that's where you stop and say, to that parcel, it's permitting. So we understand that this is a broader project that has other phases, but you made that reference specifically to the area where appellant is saying, this was for the hospital, free and clear. So again, I understand there's other parts to it, but that's not what you were talking about here.
So at that point in the description, our intention was to give an example of what highway commercial zoning does. And that's what we gave. Highway commercial, for example, permitting, and then we gave some examples of what highway commercial does. That's true. That is what highway commercial does. Furthermore, this particular project will also allow for retail establishments and will bring a broad mix of commercial business to the area. So and I guess I'm sort of...
But aren't you kind of mixing it up? You want to be separated from the other two, the specific plan? You want those to just not be looked at all because you're saying, oh, no, all we're doing is we're bringing the zoning to the voters. But now in your argument, you're saying, oh, no, we get to talk about these other phases of the development in order to bolster our position that we didn't have to say hospital. So it seems kind of going both ways.
Well, the question is it deceptive or is it misleading? So I think I apologize for skipping a step in the reasoning there. What we said about what highway commercial does is true. There's no case where someone says it's true, but it was misleading. But in any case, it's true. Not only is it true, but it's not misleading because as it happens, they are going to do these things. So even though all we were saying is, for example, this is what Highway Commercial does in that particular phrase, if you read the whole description, you'll see that we do flag the fact that there's a specific plan. And just P.S., as far as like, is it misleading? It's not. They are actually going to do this kind of work. I think when you look at Malera 1, which is the case where the court said, we know you collected several 100,000 signatures, sorry, the court's findings were strong. It was false to say that the tax would go up 3.43%. That was false. It would go up 3.43 percentage points, and the court made it clear it's false. They said, we understand the committee says the indexing of the tax rates won't happen. You, committee, are wrong, and the fact that you got it wrong, you're now keeping something from the voters. That's the bar for when the court's going to come in to a 100-word description. What you've seen is, or I think 100-word then, now 200-word. What you've seen is every time the court has had cases since then, they've said, no, we're not going to nitpick any kind of little, we're not going to say that strict compliance means, so we had in the recent case this year, the Protect Arizona or whatever, in that case, the court was like, well, I guess you could say that some secured debt, because in writing the description, the committee said that the law of secured debt would not be affected. And the court said, well, I guess it does affect the secured debt if there's a judgment of a collection action and then the court secures the debt with a, but it's very clear when you read the whole description that, yeah, of course the initiative affects that. It tells you that up top. Same thing with the contractor's case. Yeah, they talked about revenue, and if you just look at revenue, maybe you would be confused and think that it was new revenue, but the court said, no, it's very clear throughout that it's redirecting the revenue. And my point in going here is that I just think that this description, I think, reads very clearly. It tells you that it's going to be rezoned. It tells you there's going to be additional restrictions. The voter has everything they need. And also, let's not forget, there is a little warning there that says, hey, if you want to know more, tip the page up, and if you can read that first whereas if you want. So I think that I don't think we come anywhere close to the place of where we said anything. Nothing we said was untrue. Nothing we said is going to mislead anyone. And I think in looking at the court's case law, they've made it very clear these aren't the types of descriptions that the Supreme Court is interested in overturning measures over.
And our job, as you see it, is that we need to see if it's false or misleading, and that somewhere, and I forgot to flag it this morning, but when I was reading, it was saying that the description doesn't have to be neutral or impartial or as a non-advocate. So the fact that if it suits you to be able to pass this around without telling the voters that this big, new, beautiful hospital is going to be built, which may sound very enticing to you and you may want that, you can describe it as long as you're accurate and as long as you are fulfilling the requirement to put the principal provisions in. You don't have to advocate for their position. You can advocate for yours as long as you're truthful. Is that right?
That is correct, Your Honor. And I would say we got pretty close to being neutral, to be honest. I think that but you're right, it isn't required. That's right.
In terms of the use of the word hospital, it does call for hospital and ambulatory care. Now, and I referred earlier to, the record doesn't tell us what ambulatory care is. I have a sense of what that is, and my understanding is it's medical offices, it's outpatient services, it's outpatient surgery. Is that a fair assessment of what that means? And if you say can't answer, that's fine.
Your Honor, I guess I'm not qualified to answer that.
Thank you. I was just, because it seemed to me healthcare would, if that is accurate, that healthcare, the reference to Northern Arizona healthcare would include that along with the hospital.
Yes.
Do you have any dispute with the discussion I had with your colleague regarding what happens if this deal falls through?
No, Your Honor. I think it is clear that if the deal falls through and we don't, and this referendum either fails or comes off the ballot, then the zoning change is permanent unless the city takes action. That's exactly correct.
Is there a time in which the voters could weigh in later?
Well, if they wanted to change it back, so let's say either we lose at the ballot, so we're unsuccessful in referring this.
Let's assume you don't get on the ballot this time. So.
Oh, I don't want to assume that, but okay. So let's assume that we don't get on the ballot this time. The hospital falls through, Now they have
You
this.
said hotel, I think you meant hospital.
I did mean hospital.
Okay.
The hospital falls through, now they have this property zoned. If the city council changed it, then I suppose they would have an opportunity to refer them. The problem is, if they changed it using the clause about it reverting back, that's less clear to me on how that would work. So I would say, anytime there's a zoning change, you can file a referendum. But in this case, if they elected not to change it, no, the time to refer is now, and you couldn't go back and redo
So
it.
the voters could get stuck with some non-subject to the plan commercial development in the future, or even, let's say, 25 years from now. The hospital runs, it's perfect, it meets every criteria of the plan, but it ages out, and 25 years from now, they decide they want to discontinue it.
Absolutely. The zoning would be in effect, and you cannot go back. You have to refer it within the 30 days, and it would be too late.
And there are two contingent pieces, again, three moving parts. All three are subject to being amended. And there's a process in the plan to amend it, and it goes back to city council, passed by 5 votes. Is that referable at that point? Or could the city change the plan without ever touching the zoning and end up with the voters ending up with something very different because they changed the plan?
I think it's a very nuanced question. I mean,
It
the
is.
question is that what you just described, an administrative act or a legislative act? I suppose, given my clients, I would try to say something like that was a legislative act and would argue for it, but I think it's not clear at all that we would win that argument. And amending a plan that has already been passed, it's certainly not without the opportunity for opposition to say, no, this is administrative, that's not legislative.
And that part of the challenge we have is the plan is a plan, but it's not necessarily set in stone. It's contemplated, it could be amended, and the amendment could go completely contrary once the zoning's in place.
Yes.
Has that ever happened in your experience?
I don't have a horror story that I can share with you, but
All right.
I do know that in this case, it's about changing the zoning, and that's what this is about. If there's nothing else, thank you.
Do you have anything? No. Okay. Thank you. Thank you both for your arguments today. We will take this matter under advisement, and we will issue a written decision of some form or another by August 23rd at the latest. So,
That was our promise.
yeah. Thank you very much. We are in recess.